And these, the next 4 or 5 are all observations that were unanimously recommended, the first 4 of them by the Senate Standing Committee on Foreign Affairs and International Trade. So number 15 is your committee supports the recommendation of the Standing Committee on Foreign Affairs that the Government of Canada engage with the relevant U.S. federal authorities in order to develop a common understanding among Canadians and Americans of the changes in Canadian domestic policy, of the consequences of these changes, and of the different approaches undertaken by the 2 states regarding the legalization of cannabis.
Okay. Anything else on this? Is this agreed? Carried.
The next one, your committee supports the recommendation of the Standing Committee on Foreign Affairs and International Trade that the Government of Canada take such action that mitigates Canada's violation of the 3 drug control treaties. The action to be taken should be communicated in a clear and transparent manner to Canadians, the Parliament of Canada, and the international community.
Anything further on that? Agreed. Now,
Number
17 looks the same as 15.
Is it?
It's a duplicate.
But I'd like to read it again.
We've already adopted it.
Could we just approve it again, please?
No, we already adopted it.
Thank you. I'll go to 18 then.
Yeah, 18.
The committee concurs with the observation of the Standing Committee on Foreign Affairs and International Trade that the Government of Canada should examine Part 1, Division 1, Clause 8 of Bill C-45, by which Canadian youth are criminalized for behavior that is legal for adults.
Okay. Let's see. Well, I think this is over the 30 versus the 5.
Yeah. Okay.
It's legal for adults to have 30, but it's not legal for a child. Criminalized is kind of a heavy word here because I think we're. I don't. Do our officials have any comment about this particular?
Well, they will be.
Well, not you know. Earlier, when I asked Mr. Blair about that, he said it comes under the Youth Criminal Justice Act, but there are, in fact, other means of without a criminal record.
Argument that we made, and then it was argued by the chair the other way. So I think we're going back and forth here. So this is an observation. This is not an amendment.
Any comment from officials on this?
I would just refer to, I think I spoke to this issue on Friday, and earlier today when Mr. Blair was here. The distinction is, as the chair has said, between the 30 grams versus the 5 grams. When a young person would be charged with an offense under Bill C-45, it would be with respect to, for example, possession over 5 grams. And yes, the Youth Criminal Justice Act would apply throughout, and all of the provisions that are available there. So as the chair has said, if police found a young person in possession, for example, of 10 grams, police would be directed now under the Youth Criminal Justice Act to consider alternative measures, warnings, cautions, diverting the youth to a community program before necessarily jumping towards the full process with a charge, etc. Cautions are required to be documented by police since 2012, but it's still not the same full force of the process that an adult who's committing an offense would be facing.
So, anything else? Anything further on this? Yes,
I
Senator
guess
Lankin.
it's a question. We've heard testimony on both sides of this issue from, I guess, conflicted constitutional experts. And I'm not so much concerned about, I am concerned, but I can't answer the question about whether there's a real constitutional basis for concern here, because we've heard very different testimony on that. However, is it not true that even if a young person was treated with alternative measures under the Youth Criminal Justice Act, that any like violation of a condition or something like that would bring them back into a system where they could be criminalized? And how does that stand up against the intent of the Youth Criminal Justice Act? And I think about, for example, other substances, I know this is different, but like alcohol, where that's a ticketable offense or whatever, they can't at the end of the day be criminalized for that, something which, an adult can't be criminalized for. So that between 5 and 30 gives cause for concern if at the end of the day they could be criminalized for that. Is that incorrect in terms of my understanding?
So I would refer the committee to the minister's charter statement that has been tabled, that she tabled on Bill C-45, and in particular, page 39 of the charter statement speaks very much to the issue about the equality constitutional issue by treating young persons differently than adults vis-a-vis 30 versus 5 grams. I think the committee has also heard that youth are treated differently for different purposes, and whether it's at provincial law with alcohol and certainly within the criminal law as well. So to the extent that there have been differing views expressed to the different committees, I do encourage the committee to bear in mind the charter statement that speaks very much to this. Section 15 looks at whether there is a different treatment of young persons. The government's evidence and position on C-45 has been cannabis poses a particularly higher risk for young persons because of their developing mind, etc. And that's why the bill as a whole has as one of its overarching objectives to prevent young persons from having access to cannabis. And that the 5 grams recognizes the reality of the existing completely prohibitory framework whereby youth in Canada have amongst the highest use of cannabis as it is. So the idea is prevent youth from having access to cannabis lawfully under C-45. Nobody can sell it, give it, distribute to young persons, subject to the amendment adopted tonight. And if a young person, though, is in possession of that small amount, the choice that Bill C-45 reflects is that it would cause a greater harm to expose a young person to the full burden of the criminal justice system for that small amount. That said, all of the provinces have indicated and or adopted legislation that they will not allow young persons to possess any small amount through their powers, not criminal law powers.
So just a supplementary, I understand what you have said and read the minister's statement and would say, we've heard conflicting evidence around that. It's not that I don't accept her statement. What I'm saying is outside of that constitutional conflict that we've heard in terms of interpretation, is there not, and the intent I understand completely, which is to not criminalize, are there circumstances where if someone sentenced to alternative measures, if there is a breach of a condition or something like that, where they could be criminalized? That's what I understood a couple of the witnesses to say, and maybe they weren't correct.
Well, my understanding is that under the Youth Criminal Justice Act, as I've explained, there are options short of a charge. Once a charge is laid, then the overarching objectives of the Act are still to rehabilitate the young person and to move the young person towards an outcome that will help to achieve that outcome. If there's a situation, for example, once charges are laid, if there's a breach of what we would call, for example, an administration of justice offense, there are directions in there for police, again, to consider not laying new charges for that, but to deal with a more effective way with the situation. So I guess in short, my answer would be the Youth Criminal Justice Act in and of itself is completely designed to treat youth who come into contact with the criminal law in a different way than adults, to recognize their state of dependency, their immaturity, and to recognize there's a different objective here to try to get them back on the right path. And my colleague has just reminded me that if there's not a charge laid, but there's a warning. Once the young person has been issued a warning, there's no further criminal actions that would be taken under the YCGA for that incident. Whether it's another incident at a future time, I don't know.
Okay, I'm sorry that I'm not hearing an answer to my question, though, about whether in the process under the Youth Criminal Justice Act, could someone be criminalized a youth be criminalized at the end of the day if there is a breach of a condition or something in the alternative measures that were put in place? If it eventually ends in a charge and there's a condition as opposed to criminalization or as opposed to incarceration.
Again, under the Youth Criminal Justice Act, the warning, for example, is an alternative measure in lieu of a charge. A caution would be an alternative measure in lieu of a charge. Once the charge has been laid, the formal process has been triggered. As I mentioned, to the extent that there may be a breach related to that charge, for example, the youth has a condition to I don't know what that means. So police are supposed to be treating the youth before them that's been charged and to find alternative ways rather than to lay a new substantive charge going through. So once a charge has been initiated under the criminal justice system, the act again plays out how that's supposed to go forward. But it's all that pre-charge in particular that is really the alternative approach, plus the overarching objectives of the act to deal with the young person before the court. So Bill C-45 completely builds upon that. It's absolutely clear in Section 5 and now 5.1 adopted by the committee tonight that is the intention of Committee of Parliament.
Well, there's no criminal record, though, at the end of the day, even though when they say criminalize, I guess because it's the youth criminal justice system, so you say it's criminalizing them, but they don't get any criminal record and they don't go to jail, presumably.
So if there's a caution that's issued, that is documented by police since 2012. If a young person is convicted under the Youth Criminal Justice Act, there is a record that is created, but it is not a record that is accessible generally to the public. There are rules that are in place in the Act, and depending on the nature of the offense, if it's a lower end, like a summary conviction offense versus a more serious offense, the period of being able to access the record is limited. Once the youth serves the sentence imposed by the youth court and that access period is gone, the record is essentially not accessible beyond that.
How about if we change the word by which Canadian youth perform an illegal activity for behavior that is legal for adults? If we're that stuck on the word criminalized, they are doing something illegal. And it's not illegal for adults.
So what's the wording again? Which Canadian youth
are performing an illegal activity.
Performing an illegal activity.
For behavior that is legal for adults. I don't know whether but that's something along that line, and I'm certainly open to
We're
anybody
getting into
else.
doing them on the fly now. Okay, anybody else on this? Do you want to accept that change and go for it, or what? Youth are performing an illegal activity for behavior that is legal for adults.
Illegal activity that is not illegal for adults.
Are performing an illegal activity that is not illegal for adult, that is not legal.
Considered to be illegal, while not illegal.
You want to agree to that?
I have an issue. It's because it is an excerpt from the report of the Foreign Affairs Committee. We cannot change it.
Well,
Well, except
can't.
this is our report, not their report.
So we should
We're accepting
comment-
their recommendation, no, Senator.
We should comment differently because it is not what the committee, which I'm a member.
You can't concur with the observation if you change the language of the observation. I guess that's your key.
We're not concurring with it, we are making it our committee. We talked a little bit ago.
So we should add
The
the
chair
same-
made it clear that this was our committee and our observations. But in any event, I'm happy to leave it exactly the way it is and move along too.
Or if it's from the Foreign Affairs Committee, it's in their report that's on the table in the Senate.
Yes,
Well, then it certainly shouldn't hurt to have it there twice.
What about if we say the committee supports instead of concurs? So then we can, the committee supports the observation of the standing committee.
Why don't we just stick with the wording here? Otherwise, we're
I
gonna
agree.
get all.
Let's stick with the wording and move ahead.
Either supported or not supported.
Agreed.
So is anybody not supported? Do you want to agree to this? Okay, agreed.
So it's adopted.
So
Your committee supports the recommendation of the Standing Committee on Foreign Affairs and International Trade that the Minister of Foreign Affairs report to the Standing Senate Committee on Foreign Affairs and International Trade the actions that the Government of Canada has undertaken regarding Canada's compliance with the international conventions impacted by Bill C-45.
okay, any comment on that, Senator Lankin?
Senator Platt, the recommendation, I know this is another committee's recommendation, but number 16, which we adopted and support, essentially, I think, accomplishes the same thing because whatever they do to mitigate the violation that's being referred to here, they have to communicate to Canadians, Parliament, and the international community. And then 19 says you've got to also send it to the committee. It's kind of redundant.
Now, the 16 talks about action, 19 talks about that the minister reports what they've done.
16 is to the international community. Action tables.
Okay,
Okay?
you want to agree to this?
Carried. Number 20, this is from the National Defense and Security Committee. Your committee supports the recommendation of the Standing Committee on National Security and Defense to continue its dialogue with the United States government and calls on the federal government to present a plan in Parliament which will clearly and firmly communicate Canada's position so as to minimize the impact on Bill C-45, I think that should say of Bill C-45, on Canadian travelers.
Okay, anything on that? Okay.
Number 21.
Carried.
Your committee supports the recommendation of the Standing Committee on National Security and Defense that the federal government increase the scope of its awareness campaign to make it clear to Canadians that they may be denied entry to the United States if they admit to past cannabis use, including a campaign targeting youth and a campaign focused on those who hold or apply for trusted traveler programs such as Nexus and FAST.
I should point out that we had officials come in last Friday and comment on all these various committee reports. That's another reason why I say that we need to take decisions because we also had additional evidence ourselves. But one of the things we were told here is that the United States is not going to be asking the question about past cannabis use on the basis of primary questioning. I'm not saying you change this, I'm just telling you what we were told. If the person exhibits some intoxication, then that may get into questioning about the use of it, relevant to the current condition of that person. But in terms of have you ever used cannabis use, we were told by officials that in fact that would not be a primary question that would be asked. Anyway, what do you want to do with this? Adopt this?
Agreed?
Agreed? Okay. So 22. Now 22 has wording in here that says amend the bill. The bill has already been dealt with, so, and,
Just say legislation. Amend the
say amend legislation, or you could say, your committee reports the recommendation of the Standing Senate Committee on Legal Constitutional Affairs to amend the bill, impose a limit on the quantity of dried cannabis for its equivalent that individuals allowed to possess for personal use. Well, we've already dealt with the bill.
But I think it's the wording that's in the report itself.
That's in the report.
The bill can still be amended in the Senate.
Yeah,
It's
the bill could still be amended in the Senate, but I think in terms of this committee, we've already dealt with the bill. So you could take out amend the bill.
Agreed.
Impose a limit, yeah. You want to do that? Just take out the words amend the bill and
Take
then.
out the amend the bill.
Yeah, okay. Yes, Senator Gold.
Notwithstanding that I was a member of the committee that recommended it, I was here when we heard officials, and I have to say that they gave me some pause in terms of whether this was actually something worth pursuing. So, I mean, on the assumption that it's an observation and an assumption that we're not actually trying to specify what it is, I can live with it. But we heard conflicting testimony on this, notwithstanding the recommendation, at least subsequent to the committee. So I just want to register that thinking does evolve with more evidence. And on this one, I was maybe lukewarm to start with, and I'm tepid at best at this point. So thank you.
Okay, we took that.
Well, I agree with
You
you.
don't mind tepid?
I agree with you. Maybe we shouldn't adopt this one. Can we put this one aside? Is that agreed? Agreed. 23.
I would like to withdraw that. I would like to withdraw that. It is redundant in light of the amendment.
In light of the amendment that we passed earlier, yes. Okay, so let's move over to where am I now? That's 23. That's it.
No, there's.
Well, that's it for yours. I mean, no. I'm sorry. Well, I thought
There's
we
a
just
replacement 23,
where
There's a replacement.
I believe, yeah.
where I don't have a 23 change. What?
Yeah, read it.
It's number 23. May I go ahead?
Well, 23 is it not the 23 that's written here?
No, that one is redundant because of the amendment.
Yes.
So there's another 23 that was substituted for that 23.
Do we have it in both official languages? Is it?
It's not something that was submitted. It wasn't submitted to us.
Sorry.
Can you not? It wasn't submitted here. Can you not put that in the chamber on third reading? Because.
Well, it's designed as an observation.
But it wasn't submitted. We asked that they all be submitted in both official languages, and
I've got it in both official languages.
But, I mean, the other ones, we didn't have them either. They weren't submitted. There's a whole bunch of them that we're going to deal with now that weren't submitted.
well, these all came from the staff. Well, you better pass it around then. We better have a look at it.
Yeah, it's right there.
Well, while you're doing that, let me go on to these other ones I've got here.
This is Petit Claire 2.
So we've got Petit Claire 2. The committee is calling on the government to take the time. Well, anyway, I'm sorry. You go ahead and read it.
Thank you, Chair. I will make your life, our life, easier, because I feel this is covered in observation number 8 that pretty much covers the same thing. The only question I had, because my concern was
same thing as observation 8 on education and awareness. Although I did specify that I wish to see education and awareness right now, like immediately. So, but the way I read the observation 8, it says that it urges the government to provide adequate and ongoing funding. So I would assume that it incorporates that it is also immediate. Would you agree? Number 8, you're In number 8, yes.
So your committee urges the federal government to provide immediate?
Well, I'm asking for your advice whether
Number 8.
it's already
Number 8 says provide adequate and ongoing funding for
included,
sustained
like
evidence-based.
implying. It is implying, I would think, that it is immediate.
The committee is calling on the government to take the time required before Canadians can legally purchase again. It's substantially the same. You are, yeah.
Yes, yeah.
You'll withdraw it?
That's what I'm seeing.
Thank you.
In
You withdraw it. Okay, so that one is withdrawn. Now, this revised 23 looks the same as one we already adopted. This revised 23, Senator Patterson, is we already adopted one along this line. And Senator Seidman's recommendation number, find it here. Number 18.
Yeah, Mr. Chair, this is a recommendation from the Standing Senate Committee on Legal and Constitutional Affairs about the differential manner in which youth are treated under the Cannabis Act relating to the legal rights of a child.
How is that different from the one we adopted in 18?
Can you help me here, Judy?
The basis of it here in the clause, in the wording above is the same. It's the same issue.
You mean as the youth protection?
18.
As the amendment
Yes,
that we made?
it talks, for example, a young person could face criminal charge for possessing 6 grams of cannabis, where an adult possessing 30 grams would not. That's the same issue as in 18. Number 18 in your name, Senator Seidman.
Well, Mr. Chair,
Which was adopted.
Okay.
if I may suggest, then why don't we just add to 18 that the Standing Senate Committee on Legal and Constitutional Affairs also recommended that no harsher sanctions be applied to youth than are applied to adults. That gives it some more strength, having come from 2 committees which have reported to this committee. Just say they also,
Yeah.
or that also supports the recommendation that no harsher sanctions be applied to
Number 18
youth.
is from Foreign Affairs. And this
Yeah,
is
no,
from
I realize that, but I think it gets a little awkward and confusing if we, I think we made the point in 18. Yeah, but that, you know what, well, you could also say that the Standing Committee on Legal and Constitutional Affairs agreed on this, or also recommended this.
I'm just
Just
proposing
adding those words that they also agreed.
that no harsher sanctions be applied to youth than are applied to adults.
All right. Do you want to adopt that?
So
Yeah.
what is it
Maybe I
that's
was
being
sleeping, but
adopted?
we already approved this.
Well, that's what I've been arguing here.
With you.
So it's not clear to me what's.
Yeah, it begins to look, we begin to look a little ridiculous if we got to be careful of how we present ourselves on all these things, I would suggest.
Criminalization, and one's about harsher sanctions.
No, they're both about the same thing. They're both about they're both relevant to the 30 gram, 6 gram issue.
They are. I think the issue here is it
Okay.
strengthens it when you say it
It was an
Well,
observation
you know what?
recommendation.
What I would suggest is that you attempt to combine these somehow when you get into the Senate, when we get to third reading, rather than trying to do it on the fly here now. Okay, so, yes. So we just have the observations from Senator Dean, who's not here. So Senator Lankin, are you moving them?
Yes.
Well, you want to take them one at a time? There's 5 of them.
I do. Let me just indicate that I will withdraw number 2, referring to consultation with First Nations, because I think we've already
I think we've covered that.
covered that. Number 2, yeah.
Because we've covered that.
Because you've
To speak
And
against
Senator Patterson. Oh.
Senator Platt, I know you get enjoyment of speaking against things that I say, but these are Senator Dean's observations. I am doing this on his behalf. So the first one is with respect to THC potency. The issue that we talked about earlier about whether putting an amendment in the bill versus this being in the regs, and the collective decision is it stays in the regs. This is an observation that says that we support the recommendation that the labeling clearly indicate what THC levels are. And it says levels, it doesn't say percentage, and the reason for that is because, as we've heard, there will be different measures depending on the type of cannabis product that there is over time. But we support that labeling recommendation, and this is maybe a bit gratuitous, but obviously that we want it to be careful, science-based approach. And we recommend that the Senate monitor the regulation of THC levels in cannabis products and expect the minister to report to the Senate after the regulations are adopted. So it's just to give our support to that issue of proper information being provided to consumers so they can make informed decisions about their behavior and use of the product.
Why would it says the committee recommends the Senate monitor the regulation. Why would the Senate monitor the regulation?
I think that the intent here, now, maybe if I am wrong, I'm going to ask Senator Dean's staff to let me know, but I think the intent was that we wanted the minister to report back on this after the regulations are put in place, so that we can hear about the requirement for labeling and THC contents. So if you want to change that wording, I'm fine with that.
How about review instead of monitor?
That's fine, yeah.
Okay. Any other comment on this? Does that agree? The consultation with First Nations has been dropped because it's covered otherwise. Now, this next one.
Actually, number 3 has been covered as well.
Oh, yeah, we did cover that. We can
Okay,
take that
so I'm going to
out.
withdraw that. Thank you.
Okay. Pricing and taxation issues, number 4.
Yes. So we know, we've heard a lot about the sensitivity of pricing on the issue of access and the issue of the black market and the balance between that. We've also heard some issues around the actual type of taxation and its application to medical marijuana versus recreational cannabis. And this is simply saying, look, there's a balance to be struck. Don't go completely on the issue of the black market. You have to also look at ensuring that the price isn't so low that there's an ease of access. And this is the ongoing dance that we have on excise taxes with tobacco. And we see from time to time the up and down of the taxes and the reflection of the growth in the black market or the undermining of the black market. So it's all it is a flag on that there's a balance of those two things. Public health is as important as eliminating the black market.
Is that, the prices are set, is that not provincial? And tax, we're stepping into provincial territory, are we not a bit? I don't know for 100% sure.
I don't think so, but again, my understanding may be.
Okay, Mr. Costin.
The C45 doesn't ascribe a price. You're right, we can influence it through the excise tax and a few other things, but it will ultimately be set by the retailer. In most provinces, that will be a provincial crown agency, not everywhere. So predominantly, the decision on what the price is not a federal one.
So in this, it doesn't actually say which government. It recommends that the prices set reflect the dual objective, the prices and the taxes. So part of it's provincial, but part of it is definitely federal, and the actual amount of excise.
Sort of a statement of principle,
Yeah.
more than anything.
But open to whether the committee thinks it
It's a
should
good
be
statement
included
of
or not.
principle, you know. Okay,
Good to know.
should we adopt that? Great. Finally, number 5.
We've had a lot of discussion about this in a bunch of different areas. I'm not sure that it is already covered, but if I've missed something tonight, let me know. This is that the ongoing research initiatives, the money that's been announced and ongoing, is to have a real focus on youth and the effects of cannabis. So again, it's just flagging that issue because we don't have enough evidence base right now, one way or the other. And those, Mr. Chair, are Senator.
He recommends the federal government. Can you put in the word federal there?
Yes.
To make it consistent with the other ones.
To make it consistent.
Yep.
Where else do you have?
Well, in the other observations.
So just the federal government in there, okay? Is that agreed?
That's good.
Carried.
Thank you,
Okay.
that's it.
Now, don't anybody move yet.
This is just to have a steering committee approve the final version.
Also have this common practice that the subcommittee on agenda and procedure, also known as the steering committee, be empowered to approve the final version of the observations being appended to the report, taking into consideration today's discussion and with any necessary editorial, grammatical, or translation changes as required. Is that agreed? Okay, thank you. Now, okay, let me get back. Now, before I'm about to finish up here, but I've got 2 quick announcements, so please stay. They're both important. They'll be less than a minute. So, where are we now? We're at the,
Final question.
we put the law clerk thing, so the final, yeah, the final question is it agreed that I report this bill as amended with observations to the Senate? Agreed? Agreed. Carried. Okay. That finishes it. Now, the 2 things I just want to quickly say is we will, that's one of my 2 announcements. First announcement, however, is that we will not meet this Wednesday and Thursday. Hold it. We do have 2 small reports, the one on disability tax credit and the one on forced adoptions, that have to be finalized, but they haven't been sent out because we didn't want to burden everybody while we were going through 2 months of this process. So they will now be sent out a few days apart, and the following Wednesday and Thursday we will deal with them, and we'll look to see if there's any other business. But at this point in time, we won't be having a meeting this Wednesday and Thursday. The second thing I want to announce is that I want to just say thank you. I want to say thank you to our clerk and her assistants, the law clerk. I want to thank the Library of Parliament. I want to thank all those people at the opposite end of the table who've been here quite a bit, all the time, helping to guide us and explain things to us. And you've done a wonderful job. And to all of you, and to the members of the committee, thank you for hanging in for. Thank you for hanging in. Okay. So, unless there's anything else, I will declare this meeting adjourned.